The US Supreme Court on Friday agreed to hear Donald Trump's appeal of a judicial decision barring the former president from the state's Republican primary ballot, taking up a politically explosive case with major implications for the 2024 presidential election. At issue is the Colorado Supreme Court's December 19 ruling disqualifying Trump from the state's Republican primary ballot based on a language in the US Constitution's 14th Amendment for engaging in insurrection involving the January 6, 2021 attack by his supporters on the US Capitol.
As a part of the 14th Amendment, Congress held that anyone who had taken an oath to the United States, to the US Constitution, who subsequently engaged in insurrection against the United States was disqualified from holding future federal or state office. This is a provision that was, put in as part of the post-Civil War kind of Reconstruction era, clearly designed to, prohibit ex-Confederates from occupying positions in the federal government or state governments. There's a debate about whether Congress has to pass a statute to put this provision of the Constitution into effect. After the Civil War, Congress did do that, but it eventually repealed the statute. So there is no statute right now on the books from Congress authorizing, let's say, the Attorney General or the US attorneys to go into court and enforce this provision. So that's one question. Another question is whether this provision even covers the president at all. It's drafted in kind of somewhat surprising language that doesn't mention the president specifically as an institution. It does mention senators and representatives and presidential electors, all of whom are explicitly disqualified, but it doesn't mention the president by title. Then, assuming you get past those procedural hurdles, the underlying substantive questions, or the questions on the merits, are, first of all, was January 6th an insurrection against the United States within the meaning of this constitutional provision? And then secondly, whether former President Trump engaged in that insurrection by various things he did, including the speech he made on the Mall on January 6th, and including his inaction once he was back in the White House over several hours once the Capitol had been breached and it was sort of clear what was going on.
The justices made their decision to hear the case with unusual speed. Trump, the frontrunner for his party's nomination to challenge Democratic President Joe Biden in the November election, filed his appeal on Wednesday. The state Republican Party on December 17 also appealed the ruling. The state court, acting in a challenge to Trump by Republican and unaffiliated voters in Colorado, found Trump ineligible for the presidency under a constitutional provision that bars anyone who engaged in insurrection or rebellion from holding public office and therefore barred him from appearing on the primary ballot.
The president and the Colorado Republican Party have filed petitions with the US Supreme Court asking them to review and overturn the decision of the Colorado Supreme Court that President Trump cannot be on the ballot. The plaintiffs who won the litigation in Colorado have also urged the Supreme Court that it ought to hear this case. And so there's a kind of a recognition, which you don't often have from both sides, that there's a need for the Supreme Court to weigh in on this issue.
The Colorado case thrust the Supreme Court, whose 6-3 conservative majority includes 3 justices appointed by Trump, into the unprecedented and politically fraught effort to invalidate Trump's bid to claim the White House.
When the Supreme Court gets involved in a dispute of these stakes, of this significance, a dispute that is so politically charged, there's a tremendous but totally foreseeable danger to the court that the losers of the court's decision will view the court as having acted illegitimately, as having acted out of partisan motivations, because it actually prefers one outcome versus the other outcome.
Many Republicans have decried the disqualification as election interference, while proponents of disqualification have said holding Trump constitutionally accountable for an insurrection supports democratic values. Trump already faces criminal charges in 2 cases related to his effort to overturn his 2020 election loss to Biden.